It all began with a sex worker's murder in Calcutta in 1999. The woman was brutally beaten up by a man after she refused to have sex with him. While the sex worker lost her life, her case has now snowballed into the Supreme Court issuing guidelines for rehabilitation of all sex workers across the country. In today's KYC episode, I'll tell you about this story, which, like I said, began in 1999 and is still going on in the highest court of the country. Now, like I mentioned, in September 1999, a sex worker was murdered in Calcutta by one Buddhadev Karmaskar after she reportedly refused to have sex with him. Karmaskar was convicted for murder and sentenced to life imprisonment, but of course he filed appeals and the matter reached the Supreme Court. Now, in February 2011, the Supreme Court upheld his conviction, but while deciding the appeal, the court expanded the scope of the case after looking at the murder. It then directed the centre and state governments to prepare schemes for rehabilitation of sex workers across the country. The same year, in 2011, in July, it also appointed a 5-member panel for its assistance on 3 issues. You can see the issues on your screen right now. And since 2011, during the next 11 years, the matter came up before the court over 50 times, and it gave some very important directions for sex workers. For example, in September 2020, the court took note of the effect of COVID-19 and the lockdown on sex workers and directed states and union territories to provide dry ration to identified sex workers without insisting on proof of identity. Now, this panel that the court had appointed submitted its final report on 14 September 2016. It found that sex workers suffered due to lack of legal status, making it difficult for them to acquire proofs of identity like ration cards or voter ID cards. It concluded that sex workers neither had access to schemes meant for their rehabilitation nor credit facilities offered by states because they can't even open bank accounts because they don't have the required documents. In response, the central government informed the courts several times that it was working on draft laws on the basis of the panel's recommendations, but it kept asking for adjournment, saying the same thing since 2016. And now, over 11 years after the Supreme Court first expanded the scope of this appeal, the court has issued guidelines for rehabilitation of sex workers in India. But there's a catch here as well. Now, the panel made a total of 10 recommendations on rehabilitation, and there are several reports that have been since doing the rounds claiming that the Supreme Court has now made sex work legal and has recognized it as a profession. But has the Supreme Court actually done so? The short answer is no, because sex work was never illegal in India in the first place, and here's the long answer. Just to let you know, the Immoral Traffic Prevention Act 1956 deals with sex work in India. While it doesn't make voluntary sex work illegal, what it does is it makes certain activities related to prostitution illegal. For example, owning or running a brothel is illegal, so is inducing or taking someone to prostitution, forcing them into it, pimping them out. So courts have in the past emphasized on how no law in fact makes voluntary sex work a criminal offense. The law defines prostitution as, and I quote, sexual exploitation or abuse of persons for commercial purposes or for consideration in money, etc., and punishes this abuse and exploitation and those who facilitate it instead of voluntary prostitution. So now, just to let you know, one of the panel's recommendations was that the police must not interfere or take criminal action against a sex worker who's an adult and is participating with consent. Another recommendation said that since voluntary sex work is not illegal and only running the brothel is unlawful, sex workers should not be arrested or penalized or harassed or victimized when a brothel is raided. But the centre has expressed reservations on both these recommendations. In fact, it expressed reservations on 4 recommendations. The suggestion on not separating children of sex workers from their mothers merely on the ground that she's in the sex trade has also faced objection from the Supreme Court. This recommendation also said that if a minor is found living in a brothel or with sex workers, it should not be presumed that he or she has been trafficked. Now, since the centre had expressed its reservations over 4 out of 10 recommendations, the court asked states and union territories to act in strict compliance with the remaining 6 suggestions. The matter will come up next on 27 July. Meanwhile, the centre has to file its response on the remaining recommendations as well within 6 weeks. So, these 4 recommendations are actually on hold in a way right now. As for the remaining 6 recommendations, like I mentioned, those have been issued as guidelines by the Supreme Court. In fact, the court used its discretionary powers under Article 142 of the Constitution to issue these guidelines. This article allows the court to pass any order necessary to do complete justice in any case. So it's a very wide power. And it has used this provision in several important cases like Ram Janmabhoomi Babri Masjid case, Bhopal gas tragedy, coal allocation case. And now invoking this provision, it has issued these 6 guidelines at least, since the court noted that there was no law for protection and rehabilitation of sex workers. So till the government comes up with the law, the court's guidelines will be as good as the law. That's all I have for you for now. This is Apurva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on social media.